Welcome to Mayor Brown's Global Financial Markets Podcast. Each 30-minute episode is designed to help listeners better understand the legal issues that impact their business given the ongoing uncertainties in the financial markets worldwide. Speakers from across Mayor Brown's practices and offices provide their timely insights on a wide range of topics, including finance, financial services, and insurance regulatory developments, securitizations, and litigation in the United States, the United Kingdom, Europe, and Asia. We hope you enjoy the program.
Hello, listeners. Our topic today, the European Commission report on the EU Securitization Regulation. We'll discuss the recent European Commission report on the functioning of the EU Securitization Regulation and its impact for US securitizations. My name's Neil Hamilton. I'm your host. I'm a partner in the firm's banking and finance practice in London, specializing in securitization and securitization regulation. As many of you may know, the European Commission report published its report on October 10 on the functioning of the European Securitization Regulation. So just to give you some background on the report, it was a report which was due to be produced by 1st January this year. It obviously wasn't, but it's an important report in that it sets out the Commission's view on the functioning of the regulation as a whole, and also has some very important impact in relation to US issues and particularly what information EU institutional investors need to receive in order to be able to invest in US securitization. So that's probably the most important topic that we'll cover during this podcast. But just to initially give you some background on the report and its general conclusions, the European Commission concluded that the European securitization market was basically functioning in well. There was no need for significant legislative reform. There was what they called necessary some fine-tuning, but otherwise they were generally happy with how the regulation worked, and they proposed some changes more relevant to European securitizations that I won't cover here. But looking in particular at the impact on US issuers, US securitizations, there's probably good news and bad news. So to start with the good news, the European Commission looked at risk retention, one of the most important topics under the European rules, and decided that the rules didn't need to change. The quantum and the methods remain the same. To everyone's relief, they rejected the suggestion that the risk retainer had to be an EU-based entity. They've dismissed that. So it will mean that it's business as usual. US entities can continue to be the risk retainer on US securitizations sold into Europe. So that's the good news. The less good news related to the whole issue of the jurisdictional scope of the European Securitization Regulation. It's been unclear for a number of years what information EU institutional investors needed to receive in order to be able to invest in US and other what they call third country securitizations, whether, for instance, they need the full reporting that European investors would receive on a European deal, namely the templates, which we'll discuss in a minute, or a lesser version of that. And as many of you will know, there's been a practice of issuing so-called EU light securitizations, where there is compliance with EU risk retention, but no disclosure for the purposes of Article 7, which is the disclosure article of the EU securitization, no disclosure on the mandated templates. And that has worked for a number of EU institutional investors who have taken the view that this enables them to fulfill their due diligence requirements and so invest in those securitizations. Now, the Commission, importantly, while acknowledging that the legal position had been ambiguous and open to interpretation, came down fairly firmly with its legal interpretation that if you're an EU investor, you need to get exactly the same reporting on a US deal as for a European deal, which means the full panoply of Article 7 disclosure and templates, which we'll look into in a minute. So they were fairly firm in that conclusion. They recognise, however, that the prescribed reporting was what they call disproportionate, not really needed, and certainly not ever generally read by investors. And with that in mind, they've invited ESMA, the European Securities and Markets Association, to look at revising the templates, not just revising and simplifying the templates for public deals, but also developing a simplified template for all private deals, which could cover one template for all asset classes. So therefore making it very much easier for US originators to comply with template reporting. And just a sidebar on the meaning of private deals. For EU purposes, a public deal means one that's required to produce an EU compliant prospectus. So most US deals with an offering circular, say listed on the GEM market of the Irish Stock Exchange or the Vienna MTF, will be a private deal for these purposes. So that was good news. Of course, the catch with that is that the new template, particularly the new private template, will take some time to produce given the European regulatory process for considering and approving the templates. So there is a transitional period between the publication of the report, when the Commission has said that essentially European investors need to receive full template reporting, and the time when those new simplified templates are actually adopted. It's worth saying that this was not a new piece of law, not a new, not a legal act as such. It was an interpretation of an existing piece of legislation, and therefore, for that reason, probably there's no express grandfathering or transitional period in the report. And it's generally thought by all in the industry that this essentially means that this interpretation is binding, effective as of the date of the report, meaning that from a strict technical perspective, European institutional investors need to receive the full template reporting. So what is required in terms of compliance with the EU disclosure rules, the Article 7 disclosure? There are essentially three elements to that. Firstly, there's disclosure that's required, what the rule called pre-pricing, and that is the transaction documents, a transaction summary, which is often included in the offering document. And those are typically will be uploaded at the time of the red offering circular to a dedicated website. So there's pre-pricing disclosure. The more onerous provisions relate to the ongoing reporting. There's both an investor report and an asset level report, and there's different prescribed template developed by ESMA for each individual asset class, and to the extent an asset class is not covered, there's a catch-all called esoteric for deals that don't quite fit within any of the other annexes. These templates are quite challenging to fill in because they've got a number of data fields, over 100 in some cases, and clearly that will be problematic for many US originators and issuers to produce, simply because often they will not produce this information in the course of their business. It may not be relevant to them, or they may report in different formats. For instance, the CREFC form of report for commercial real estate. So quite difficult to complete these reports in most cases. For some asset classes, CLOs, for instance, it may be possible for the templates to be reported without too much administrative burden and expense by using specialist third-party reporting agents, but that won't be possible in all cases. So that clearly leaves us in a bit of a dilemma during this transition period, both for European investors that don't want to lose the commercial relationship. For instance, if they provide warehouse facilities to a US company, and for US originators that would like to be able to comply with what the investors need, but may not be able to turn on a dime and do that instantly. So, how are people dealing with this transitional period, and what's thinking in relation to different categories of deals. First of all, there are legacy deals, that is, existing deals in which European investors are invested, but which don't currently comply with full Article 7 reporting. There, I think people generally think that there isn't any requirement for a fire sale, which clearly wouldn't be in the interests of investors. In particular, if investments are held by alternative investment fund managers through their funds, the fund management directive expressly says that the manager has to act in the best interests of investors, which is clearly not to fire sell the assets straight away. And I think most commentators and law firms take the view that for existing holdings, the risk of regulators taking action if there's no immediate sale is relatively low, although of course it cannot be ruled out completely, but is thought to be relatively low. So that's the legal position as to what's required under Article 7. It may be legitimate for investors, obviously, to make their own risk assessment as to whether they may end up having something less than full compliance, but that's really a decision for the individual investor from a policy perspective and a practical and commercial perspective. It's also worth noting that the industry is putting a request to ESMA for a form of equivalent to a no action letter, requesting that in this interim transition period, there should be relief given to parties that are doing their best to comply, but not necessarily able to obtain the full template reporting during that transition period. So we don't know how such a request might be received. On the one hand, it makes a great deal of sense, particularly since the Commission has itself said that recognized that the current form of reporting is not proportionate, and they're going to encouraging ESMA to move to simplified form of reporting, in particular a radically simplified private template. On the other hand, the Commission report does make reference to European investors' competitive disadvantage and de facto not being able to invest. So it suggests they may think that it's not appropriate for investors to invest during this transition period. So the jury is still out as to whether that relief will be forthcoming, but we certainly hope that is the case. So that is a summary of the main impact of the Commission report on the EU Securitization Regulation for US issuers and originators. So thank you to our audience for listening. Listeners, if you have any questions about today's podcast or anything else related to global financial markets, please email us at gfm@mayorbrown.com. Again, that's gfm@mayorbrown.com. Thanks for listening.
We hope you enjoyed this program. You can subscribe on all major podcasting platforms. To learn about other Mayor Brown audio programming, visit mayorbrown.com/podcasts. Thanks for listening.